Good afternoon. This is the Oklahoma City Building and Fire Code Board of Appeals. This is our scheduled meeting for the month of March. Today is March 12th. And we are going to ask for a roll call in a minute. Here.
Here.
Austin Burton? No. Ann Weber?
Here.
And we have one vacant position, but we do have a quorum.
Thank you. Our first order of business is to elect the board chair. Do I need a motion and a second to do that, or we just go through? So can I have does anybody care to make a motion? Second? A second to actually have the election.
Oh, to hold the election, okay, well, yeah, go ahead.
I thought that's what we were doing.
Do I have a second?
Second. I second.
Okay. Are there any motions on the floor for chair? This is where we make a motion to put a name on the floor or names on the floor.
I'll make a motion for Kyle Lombardo.
I second.
I have a motion and a second. That was Tommy and Patrice.
Okay.
Patricia.
All right, just do all in favor?
We can do all in favor under the small board rules.
Yeah.
All in favor?
Aye.
Okay.
Opposed? Hearing none, the ayes have it.
Okay.
I'll make the motion, or I guess I can't really make a motion. Can I have a motion to conduct the election or hold the election of the vice chairman? Do I have a
I
motion?
second.
Do I have a motion?
Oh,
Motion.
Jim McWhorter, second. Patrice, your second.
second.
Okay. Who was the nominee, he said?
Do we have a motion for a
Me?
nominee?
Oh, no. I thought he was asking.
Yeah.
I
Who
nominate Tommy
Tommy?
Willis for vice chair.
So I have a motion. Do I have a second for Tommy?
Second.
Okay, Patrice and Ann.
We have a motion from Patrice and a second from Ann.
Okay,
You want to call the vote?
yeah, or just do all in favor?
All in favor?
Aye.
All right.
Opposed? Hearing no opposed, the ayes have it.
Okay.
Go ahead.
Agenda and your file.
Excuse me. How are you?
Just to make a note for the record, Austin Burton has joined the board. So, do we have a motion to review or to adopt the amended bylaws? Item number 4.
I'd like to make a motion to, have we done the minutes yet?
No, that's after this.
Oh.
We could, you have the authority to change the order of things too, if you wish.
Would someone care to make a motion to do the minutes, to approve the minutes?
I'd like to make a motion to approve the
Second.
minutes. Second.
Okay, I believe everybody's gotten a copy of the minutes and had a chance to read them. Do I have a motion to approve?
Motion to approve. Second.
So it's Ann and Patrice. All in favor?
Aye.
Opposed? Hearing none, the ayes have it. Next order of business then will be the introduction and adoption of the amended bylaws. Do I have I'd like to have a motion to approve the bylaws, and then we can discuss them. So do I have a motion to approve the bylaws?
Motion.
Second.
Jim? Second?
Austin.
Austin? The floor is open for discussion. I personally had one item I would like to clarify. It's under section 5, and it's under attempts to influence members outside hearing. First sentence says, "No member of this board will listen to any person interested in any case pending before the board at any time except at regular hearings." We've had discussion about members being able to present or to actually participate in discussions about particular cases, even though it may be something that they may have been involved with. And then, of course, they couldn't vote. They'd have to recuse. But this goes to another concern I have, that if you happen to be in a firm or working with someone who does have a case before the board, it specifically says you essentially can't talk to them about anything. It's not specific about the case. It says they may have some interest in the case, but it doesn't say that you can't talk to them about anything other than the case. So I would like to change that wording to say that no member of this board will listen to any person concerning matters about any case pending before the board at any time except at regular hearings. Because I think, and I've actually had this happen, where there was a case before the board in a firm I was working with. I was working with the same group of people on another project. I'd like to be able to talk to them about the other project. And by the letter of what was written here, I would not be able to do that. So
I've amended the language, I believe, as you just mentioned. Does that look correct? It may be on your screens as well.
it's section 5, yeah, right up, yeah, right. That's exactly what it should say. Yeah, you can press the presentation button.
Why did I not see that?
Hmm?
Section 5.
It's on the back of the first page,
Oh, okay. Here it is.
down towards the bottom.
Got it. Thank you.
So I have a question.
Yes, sir.
Is this like, I understand what you're saying about firms and relationships there, but this, I've been in the past, it's been several years, but somebody that knew I was on this board and called me about, can you help me get this through? And all that. And I just said, no. I said, you have to come to the meeting and present your case.
That's correct.
And I said, there's 7 of us that make that decision, and I can't really talk about it. And
Right,
so, and I thought that was correct.
right, it is.
And
That's my understanding.
So I would perhaps recommend on this one as well, because the existing language almost, it made me feel that they were actually saying that you couldn't hear out anybody. It doesn't specifically say here, it says no member of this board will listen to any person, when really I think this ought to say that no member of this board may vote concerning matters pertaining to any case pending before related to them.
Well, let's go back to when the Mercy Hospital, the Women's Center. I went and visited them, and they talked to me.
Yeah.
Here's this, and here's what we mean, blah, blah, blah. Well, I listened to them, and they weren't trying to persuade me. They were just explaining to me what they were talking about. So is that
Well,
Was
true,
that-
because this is matters of influencing board members, so, okay, yeah.
So would that be considered an influence because the way this is worded, no member of this board will listen to any person. I think that listen to any person is the wrong wording, because there are times when we go out to a site and they're going to, I've done it a couple of times where people say, well, here's what we're showing you. And they're not trying to influence me, they're trying to explain the situation. So,
But isn't whenever they're here to present, isn't that their time to actually do the best they can in explaining it?
Yeah. I mean, I think.
You know what I mean? Like, plead your case, essentially.
I mean,
Right.
I would believe that under the intent of like the Open Records Act, Open Meetings Act and all that you would want to hold any discussion here, obviously, so that both sides, yay or nay, can hear each other out. You don't want anything spoken outside of this forum that wouldn't be, that somebody couldn't argue against, vice versa.
and it's like when I went, excuse me, when I went and talked to them, first thing I said, listen, I can't discuss this with you. I'm just here to review the area and take a look at what you're talking about. And they said, that's fine, blah, blah, blah. And so that's the premise I've set up when I walked in. I'm not here to discuss this with you. I'm not here to talk to you about this. I'm just here to look at the situation.
So I mean, maybe the better language would be, no member of this board shall actively engage in discussion.
Actively engage in discussions pertaining to the
yeah.
case.
Because you can't stop somebody from talking to you
That's
if
right.
they catch you on the street. But you can, decide whether to actively engage in that discussion.
Right.
So I have a question. I'm thinking back to, I understand why you might want to visit a place or something, but it's been, goodness, Kyle, you were on the board before I was, and I've been on for over 15 years. And I was told in the beginning that we weren't allowed to go visit any of the places because of that. Somebody might try to talk to you or influence you or something like that. And I was told that when we were sitting at the table when they said, hey, we need to get you on the Board of Appeals. And they were at one of the home builder luncheons that we were sponsoring for city officials. That was like in 2009 or something. And so, but was that incorrect?
There's something in here that
Yeah, I mean, I wouldn't be able to say one way or another myself. We were supposed to have legal counsel here today. I mean, it's something I could take this to, after this meeting, between now and the next one we hold.
Let's,
So we'll get
why don't we do that?
that aspect, so.
Does everybody agree that we should probably have legal counsel answer the question about site visits and the language that we have here?
Well, yes, I think the language would be pretty simple to do, with the way that she was just talking, about, and what Scott said about not engaging in any discussion about any of the cases outside of this room, outside of the formal meeting and hearing. On that, I think the site visit is a separate issue, personally.
Right.
Yeah, I can see that. The site visit, again, it was very educational to go and see what they were talking about. And I've gone to one where they had the pool and one where they had the bathrooms and took pictures for us all to see. And I believe in here, it does say that we can do site visits. I thought I read that.
It makes sense to me what you're explaining, Patrice. The only problem, I guess it's really confusing just because it's like, if only one person goes to the site or two people, and say there's a little bit of extra language or explanation given on site, but it's not given here when we're supposed to be like, saying yay or nay or whatever, it just doesn't seem, we're not getting the full picture. So when they come here, they should be providing us a full picture, a full explanation that would explain why they need this to happen. You know, that's the only problem. There's no doubt that I think it's nice. It is very helpful to go to the site. There's no doubt. But I guess it goes back to the whole legal, talking to the legal group, and like, can we do that? If we-
Section
Yeah.
3, testimony and documents, it says, "The board may listen to testimony and inspect any data or sites as it deems necessary to enable the board to render a fair and informed decision." So
I thought it said.
you can, I think that it, I think going forward, it would probably be, you maybe clear it through Scott and say, hey, we're going to go do this, and then invite any other board members, and then we go out represented.
Yeah, but you have to be careful, you can't have more than 4, or you can't have 4.
That's not what this says.
I know, we need
That
to,
makes more sense if it was like, if there was a date and there was like multiple of us.
And Tommy, which publication are you reading?
It's under section 3.
Okay.
It is subsection D.
see, that's,
Oh, Article
Article 3.
Oh, there we go.
Oh, sorry, yeah. Article 3.
Article, section 3.
Yeah, Article 3, section 3, D.
So I thought that was, the way that was worded, and it's probably just me, but a pre-site visit is one thing, but when it's not clear as a result of a presentation in here, that's when I would think it would be okay to have a site visit so that we could make a wise decision. If it was a situation that we just didn't understand or was very controversial or could be a major liability to the city of OKC or something like that, because that's our responsibility, is to protect our city. And so I think there's some legal wording, some legal jargon, not 10 pages like, because attorneys get paid by the word. And that's a joke, but anyway. Does that make sense?
Yes, that makes total sense.
We had the one where the railroad crossing. And I just could not, in my mind, see how close that railroad crossing was to the building. So I
Right.
went and looked at it and was able to say, yeah, this is 15 feet. It doesn't look like that in all the drawings and pictures and stuff, but I went and looked at it. Yeah, this looks like it's.
I know what you're talking about in that particular case, but I had actually seen it before. I had been there before for another reason, and I had just seen it, and so I could visualize it in that, in that case. If you don't understand, then I don't think it's unfair to ask for a continuance or something so that you can visit, clarify it, and go on, and not have them there to discuss it with you.
so Scott, you have 2 issues you're going to discuss so far?
Yeah, and the one thing I'd add to this too, that I'll probably bring up with legal as well, and I think, Ann, you kind of hit on it also. I mean, in any other court of law, right, and I know this is kind of a semi-judicial body, but any other court of law, right, the burden of proof is on the one bringing you the case. So, I mean, yeah, I think there are scenarios when a judge may, want something else or go above and beyond, but I don't know. I guess my question is whether or not that would overrule our ability to go out either before or after a hearing as well. So I'll ask about that.
Yeah, I would I would probably tend to agree. Now that I really read this, I would probably tend to agree with, I think that probably the intent of this would be that they could, during the hearing, if they wanted to have it on site, right? I think that they could say, as the board, you need to see this.
Well, they would have to be able to know ahead of time.
Right, but I think that that's what this gives them is, because it is, Article 3 is really for during the hearing, so I don't know if it necessarily would address before or after. I think it really is talking about.
Now, the other thing I'd like to bring up related to this point as well, in certain cases we've had fire-related storm shelters and so forth, any one of the board members here today or others that were with us then, you've had your own expertise in certain areas, and there's been times in which we've been able to discuss some of these things with the applicant afterwards. Whether it be, okay, hey, I know a guy, here's a cheaper way possibly, you know.
Sure.
I kind of feel that that may be part of this as well. We definitely want clarification on.
But a lot of that too
I
is
agree with that,
already-
Scott. That's
Yeah.
exactly what I was thinking, because like we've had some of these fire issues, and I know that I've been and even through you,
Yeah.
they've contacted you, and stuff has been sent to me, and
Yeah.
I've often wondered if that was, really acting on behalf of
I mean,
the entire
I
board.
can understand it after the board's already ruled for or against
Right.
the case. The case
Right.
is over, it's done.
Yeah.
But, yeah, I just want to be
Yeah.
safe.
Most likely, we probably shouldn't be rehashing the case once
I don't know.
it's, they may feel they can come back and re-input some kind of paperwork and get a change.
I think they're allowed to come back after 3 months.
Yeah, there's a limitation, a cooling period, I think, yeah.
Well, the reason I was saying that, I think we're getting kind of nitpicky, and I think this would be something far and few in between, because I'm just thinking about how many years we've been on this, and I don't know of it ever being an issue before. But on the other hand, maybe the wording needs to be in place just to protect the board, protect the city, protect Scott.
Like I said, my concern was just knowing that the way it was worded, I would be in strict violation, according to the wording, talking to anybody in my firm who might have a case before this board, whether it was about the project or not. So you have those two issues, those two items so far?
Yes.
I have one other one, and then I'll give someone else the floor, but I wanted to get an opinion about whether Section 6 under Article 2, I guess, is it?
I believe I've got it
So
up on the screen.
it's under Article 1,
Article 1, okay.
Section 6. It's right underneath where you were working before.
Okay.
Conflict of interest. And I wanted to make sure that we were clear that even though you may have, your firm may be working on a project, or you may be working on the project yourself, that you can still participate in discussions, but you can't vote. Because, for example, if Tommy is working on something that happens to do with fire protection or something like that, he used to be the only expert up here that had to do with fire protection. And we'd want to hear his professional opinions during the discussion, but perhaps, certainly he couldn't vote on something that he was directly involved with. So I wanted to make sure that Section 6, conflict of interest, item A, still allows the discussion during participation in discussions.
And I guess my curiosity with that is, if in that hypothetical scenario, Tommy, let's say, if he had to recuse himself from voting, even if the board limited his ability to even speak on it as a board member, would he still not be able to approach, the bench out here, so to speak, as a citizen in that case and say the same thing? So, is the intent to stop him from speaking at all, or just the vote?
So if you'll ask the council that, we'd appreciate that. Anybody have anything else of concern?
The members, section 1. So we're trying to figure out the 3 citizen members who are qualified by occupation, experience, and training to pass upon matters pertaining to building and construction. As of right now, as it says right now, we have 3. That would be individuals who are engineers or building people. So we've dropped that from 3 to 2.
Mm-hmm.
And then the 2 additional members are for the fire and safety.
Correct.
And then we've taken away one of the citizen members.
Yes. Yeah, this, and I apologize, this got mixed up between your version and mine, Patrice, so I had to add it back here today. But yes, the Fire Code Board of Appeals was created roughly this time last year. I don't know that they had any cases or even had any board members. The mayor's office had requested that their board and ours be combined due to the nature of both boards, and this was the result. So, yeah, they did reduce the number of citizen members down from 3 to 2, and then added the requirement for the two members with fire experience, more or less. So by doing that, Tommy, I believe, Tommy Willis, you were technically moved over as one of those fire specialists. Of course, we lost Ron Roque. Well, he was kind of resigning from the board anyway. The time was beneficial to both, but we would have lost his seat due to that as well. So we have the one vacancy for fire specialist at the moment.
The total number is still,
Yeah, total number is still 7. Yeah.
Are we still going to appoint, is the mayor still going to appoint 2 alternate members?
Well, actually, we've never had alternate members. I know a number of other boards do, from what I understand, Board of Adjustments perhaps, or some of these other advisory boards, but I've never, in my experience, seen one appointed. I'm just not sure. Maybe it's something that the mayor's office just wasn't aware of. I almost feel that it would be a good idea. There has been a few cases where we haven't been able to make a quorum, where somebody's had to call out late. And with such a small board, it does come up from time to time. But yeah, we've never used it, though. It was existing in the language.
Well, you know, I would feel sorry for anyone who'd be an alternate, because they would probably never hear, very seldom, would be able to hear a case. I mean, I don't know that I didn't know we've ever not met a quorum.
There's been 1 or 2 in the last 4 or 5 years. It might have been prior to Patrice you coming on, perhaps, or yeah. Yeah, this is fairly rare.
So the key word here is may.
Yeah.
If an issue comes up, he can appoint. It doesn't mean we have to have them.
Yes, I mean, I would agree with you on that one. Now, where are you reading this alternate member language again?
Section 1, paragraph B, the first sentence, the Oklahoma City.
Oh, there we go, yeah.
May appoint 2 alternate members.
Yeah.
So may means if he sees a situation where he thinks it warrants alternate members, he can ask for alternate members.
Now, the language here for the alternate members, it isn't specifically requiring them to be of any one type of those 5 listed above, right? The problem I've seen with some boards, not necessarily within Oklahoma City, is that the alternates have to be specific, such as OUBCC, and it has to be that particular member that's absent for you to vote. As generic as this is written, I definitely think it would be more beneficial if we had alternates, because then, you know, again, a day like today, you would have a 7th member, or if one of you had called in, we'd you know, be able to bring in both. But yes, I do think the language may there kind of gives an out for the mayor's office if we can't find anybody. Again, we're still trying to fill a vacancy right now. I don't know how easy it would be to find 2 others in addition. So.
I do have one more item if anybody else, or does anybody else have anything? The last, oh, go ahead.
Oh, my only thing is that last page to delete that attachment wording.
More in there.
On the last page where the chairman and clerk of board of appeals signs on the last page.
It says the Roberts Rules of Order cheat sheet.
Yeah, just take that off because we're not putting that on there.
Okay, they'll direct me to it. Where am I at
The
here?
last page,
Last page, last item.
take off that
Oh.
attachment.
I see what you're saying. Okay.
The item I had is actually pertaining to that.
I think I've got it pulled up there.
Yeah, if you go to the next page. See, I think that Article 6, item A, says that we're going to go by Robert's Rules of Order. And it says, it goes on to say that in accordance with Robert's Rules of Order, paragraph 4921, procedures in small board meetings, the board may adopt rules which are modified for small board meetings. I'm wondering, there's a couple things come to mind. Should we just do that now? Or is this something that we should, we'll have to do at the beginning of each meeting? My preference would be just to say that that's what we're going to operate under until further notice. So if we just want to write it in that way.
Let's see.
There's actually seven subparts of 4921. And they're not real long. They could be added to Article 6, Rules of Order. You want to look at this?
Okay. So just to,
It's 4921, those last.
okay, so we're thinking to add
Just make
all
those.
7 of those bullet points,
Yeah, we-
instead of just
more or less that
saying-
whole section.
Yeah, instead of just saying we can do it, if we put it there, then we
We'll do it.
will do it, yeah.
Okay.
So we just change that whole paragraph to say we're going to operate under paragraph 4921, Robert's Rules of Order, procedures in small board meetings, and then list all 7 of those items. Are those all inclusive?
You can read them, but they're pretty. And that doesn't mean that the Robert's Rules of Order change, it's just that you're paring it down a little bit to what the requirements are, not that you can't do other things. I have both of them, the condensed version and the long version. Who would ever think there's so much rules about me?
That looks fine.
Okay, so we'll read the Robert's Rules of Order, paragraph 4921, procedures for small board meetings shall govern the Oklahoma City Building and Fire Code Board of Appeals in all cases which they are applicable and not inconsistent with the bylaws or special rules of the board.
Okay. Are there any other changes people would like to see? If not, what I would like to do is hear a motion to continue and then ask Scott to take this before council and let them look at it to make sure that we're, in line with what they expect.
Motion.
Is that Jim?
Yes.
Second,
Austin?
Austin. All in favor? Aye. Opposed? Hearing none, the ayes have it.
Would everyone, I can make copies of this and send it to everybody, if anyone would like to see this, because things like, motions need not be seconded.
I think we may want to put some rules in and just modify
Okay.
You know, if you can't get a second, you're probably not going to get your. No, I've been on boards where a motion is made, it's seconded, and then the discussion happens, and it's determined something needs to change. So you have to have somebody who says for a second, says the motion. Yeah. Or you vote on it and you vote it down. We had that happen in the meeting when we were meeting over in the other building, and we had a group of people, I forget what we were talking about, but we were trying to, it was the wall at the firewall at the parts store. And we had a motion, and then we decided after the motion and the second were on the floor that we needed to kind of rethink it. So we had to back it all, or we had to vote that one down so that we could get to the next motion. Yeah. So, so we're all, you're going to go ahead and take that to the
Yeah.
council? and-
Yep. I will get with legal.
So next order of business. We've already voted on our minutes. New cases? None.
Yeah, none this time.
We have no continued cases. New business? Any new business?
Yeah, none so far.
So next item is adjournment. Do we have a motion?
Motion to adjourn?
Second?
Second.
It's Tommy and Patrice. All in favor? Aye. Opposed? Hearing none, the ayes have it. We're adjourned.
Okay.